Mr. the Ambassador of the Netherlands, every participant here tonight, online and here physically with us. I would like to wish you a very warm welcome on behalf of Mazar. It's always a pleasure to support the French Embassy or our friends from other European communities to welcome you here to have events. But I think today we are more than happy. I think today we are proud to be associated to this conference today on the sexual harassment. For Mazar, it's a very important topic, and as an introduction, I won't go in the details of all the policies and education that we do to our staff, but I'm very happy at a later stage during the conference to answer questions or give a little bit more comments. I just want to say that a big welcome again to all of you, and I'm looking forward to the discussions today. Thank you very much. Thank you.
All right, thank you. Good evening, all. I just want to say thank you again to Sebastian for such a warm welcome, and for Mazars for hosting this very important conversation. I would still just like to remind you to please keep your masks on, sanitize whenever you get the chance, and remain socially distanced. My name is Tina Redman, and I'll be your MC for this event this evening. I'm a presenter, an actor, a writer, and director, and I was involved in easy training when I was approached by Frankie Opperman. Let me take this off. I was involved in easy training when I was approached by Frankie Opperman. Him and his team had created this program where employees and employers could learn about sexual harassment in the workplace. And you would think that this is a fairly easy concept to grasp, but actually it's not so in your face. There are subtleties that we as employers and employees need to learn about. So having your employers put structures in place to learn about sexual harassment not only strengthens the community of the workplace, but also ensures that the workplace is a safer and more respectful environment for all. So today's event is organized by the embassies of France and the Netherlands and Easy Training in partnership with Mazars on the back of a training course on sexual harassment developed by Easy Training. My colleagues Stefan van der Walt and Dr. Emil Haarhoff will tell you a little bit more about that later. Please note that this event will be live streamed on YouTube and, if I'm not mistaken, Facebook as well, just so that those who aren't here physically can also join in on the conversation. So sexual harassment in the workplace is something we often ignore, yet it could be happening right on our doorsteps, and we need to prepare and put measures in place to tackle it. And this is why we invited you here today, to talk about what it means, what South Africa's laws that have been put in place will do, and what your company and yourself can do to tackle this. Our aim is to contribute and ensure that there is a safe and respectful environment for all. Combating gender equality, discrimination, and gender-based violence is on the high end of cooperation, of the cooperation agenda between Netherlands, France, and South Africa. Mr. Aurélien Lescheur Vallier and the ambassador of the Netherlands, Mr. Hans Pieters, are here with us today, and that's a testimony to the work that's being done here today. Without further ado, I would like to invite them to take the floor and to officially open the program and to share their insights on this important topic.
Thank you very much. Thank you, Tina. Need to switch the mic on? Thank you very much to all of you for being here. It's great that after such a long time that we are gradually going back to in-person meetings, and let's hope that the third wave is not going to be a spoiler, but so far I think things are going pretty well, at least compared to the Netherlands for some months now, the situation in South Africa has been much better. Finally, this week the numbers also in the Netherlands are coming down, so we see that the vaccinations have some impact. And let's hope that the third wave, if it comes, will be the small one and not the big one. Very proud to be here, and thank you also to Mazars for receiving us for this, I think, exciting and very important workshop. Very proud to be here with also my French colleague. It's always good to partner up with your friends, and certainly on issues like these. I think the emergence of Me Too a couple of years ago finally opened our eyes when it comes to inappropriate behavior at the workspace. And sexual harassment in the workspace is a violation, basically, of one's dignity. And the right to safety and security is very important, because if we don't respect this, then we in fact devaluate persons. We make them almost like objects. And I must confess that also I, at some point when I was younger, at a bar, at the guys' night out, may have made jokes which certainly I will not make again. Because I think the thing is that it seems innocent, but the problem is it's not. Because the effects of sexual harassment in the workplace, they really take a toll on people and can affect productivity, mental health, well-being, and also the staff morale. And there is unfortunately still an underreporting, I think, of what's taking place at the workplace. Men and women fear the consequences of speaking up. They fear that they might be victimized. They fear they might ultimately maybe lose their job. So we have to try to create an environment in which, one, of course, we try to diminish the whole phenomenon of sexual harassment, but also make it easier for people to speak up, because it's certainly not easy for people to speak up. Of course, especially people in the group of LGBTI, people who are disabled, they might even feel more victimized because it's still a little bit more difficult for them to express themselves and to be whomever they want to be. So for those reasons, I'm very happy that we have this evening together here. And I think that the training courses, such as the one designed by Easy Training, they really can address the need for companies and other entities to improve the levels of understanding of what basically constitutes sexual harassment. I already said it seems all innocent to make your joke. What can be done in order to prevent further cases? And how can we enhance protection of our staff and bring perpetrators to the book? So once again, very grateful and very happy that this event is taking place. I wish all of you a very good evening, and once again, thanks a lot.
Thank you very much, Ambassador. Thank you, Tina. Good evening to everybody. It's a pleasure to be with you tonight. My name is Aurélien Le Chevalier, and I'm the French ambassador to South Africa. I think every time we have the opportunity to participate in such an event and to raise awareness on sexual harassment in general, we should be a part of it and devote our time to pursue these awareness campaigns and this collective fighting against sexual harassment. When we think of sexual harassment, what comes to our mind is maybe the private places, maybe the public spaces, but not in the workplaces. But we have to know that unfortunately there are places at work that become for many, many people around the world places of sexual harassment. It's not only a South African problem, it's a global problem, it's a global phenomenon. It's the case in France too, and unfortunately it's a huge phenomenon. In France, for example, the last studies showed that 30% of the women declared that they had they were confronted, they faced a problem of sexual harassment in the workplace. So it's very significant. And in 1991, so a long time ago, it was only 19% of the women. So maybe it shows that today the reporting is better, which is a positive development, that's a progress, but still it reflects also the fact that it's really a huge phenomenon. And I think the figures are almost similar in South Africa. Mm-hmm. For example, according to the last studies, around 30% also of women testifying that they have suffered from sexual harassment in the workplace. So we really have to do something about it, and tonight is an important event for us. We've been working on that event for, sometimes we want to really build a platform with the right partners. And actually, I won't be too long, I just want to thank our partners for this event, and to say that now we are really counting, of course we will continue to participate, but we are really counting on everybody to move forward and to lift up this platform to create more awareness and more training on this very important topic. I would like to thank Easy Training. So they have designed the training session on sexual harassment in the workplace. We were privileged enough to work with Easy Training at the embassy. We co-designed part of the material used for the sexual harassment training session. It's very good. Actually, everybody at the embassy and in our two consulates in Johannesburg and Cape Town, they attended the program. I did it myself. It was not voluntary, it was compulsory, and it was a success. And everybody learned, everybody interacted, and I think the awareness was really raised thanks to this very important and interactive Easy Training session. So we will learn more about it in a second. I would like to thank, of course, my dear colleague Han and all the team from the Dutch embassy. It's great to partner with you. The Netherlands are a leader in the world in terms of preventing sexual harassment and fighting against the consequences of sexual harassment. So it's a great partnership, and we really count on your dedication in the coming weeks and months. Thank you very, very much. Mazar hosting the event. Mazar is a French South African company, very known to be an auditing company in terms of accounting and tax systems. But I tend to think it's not a coincidence that we're here, because the fight or the prevention against sexual harassment should be part of the auditing of any company, right? Mm-hmm. In terms of accountability, because when you think of the safety of the workplace and how women and men must feel secure in the place where they spend so much time, actually, and where they want to be free and to feel that they can safely work and give the best out of themselves, that should really be something that is well scrutinized and monitored and followed by all the kind of processes that we have around the companies. I would like to thank also Fesken, the law firm. We will learn more from them. We don't know each other yet, but I look forward to your presentation, and I thank you for your legal insights, and that will really, I think, strengthen this platform that we are building at the moment. I would like to thank also the South African French Chamber of Commerce, very well represented tonight with Sophie Ferrand-Hazard and Yves Guénon. The Chamber of Commerce will be very important, because what we want to do tonight is, of course, to raise the awareness for the participants, but also to try to create an outreach for more private companies to participate in these programs. And maybe to say, yes, I want to be the next one to develop internally this program for my workforce. So the Chambers of Commerce, I think the Netherlands can participate also, our European partners and beyond. They can say, okay, let's start with these collective sessions, and then the different private companies will participate. And last but not least, I would like to thank the team at the French Embassy, Noël, Chloe, Lorraine, also, they've been working a lot on this session, and now it's time for me to stop and to listen. Thank you very much.
Thank you so much to both the Ambassador of France and the Ambassador of the Netherlands for such insightful remarks. I also do agree that this type of training, easy training, should be compulsory in workspaces. We need to start holding each other accountable. And this is a great and easy way to do so. And now you can't say that you didn't know, because now you've done the training. As I said before, we're very honored to have you both here with us tonight, and your presence goes a long way to emphasize the commitment and that both your countries have put into tackling this issue. Now I'd like to take a moment to speak through the meaning of sexual harassment and why it matters. I will be speaking about sexual harassment in detail from here onward, and it may be triggering. I ask that if you are in the audience and you do need a break from this, please step out and take care of yourself this evening. We do have legal experts who will be speaking to us about legislation afterwards, so I will not go into detail about that. I do want to speak to everyone on a more personal level going forward, just so that we know what the examples of sexual harassment are, how do we recognize it, if it's happening to you or a colleague, and most importantly, how to prevent it from happening, and what we can do to stop it. Firstly, I hope you don't mind, I will be making this part of the evening a little bit more interactive. But you don't have to worry, I'm not going to get anyone to volunteer and come up onto stage. I will just be asking a few questions, and I would appreciate it if you could please get involved, answer if you can, put up your hand where necessary, or don't. So anyone who's had the opportunity to do easy training will know that it is a very interactive type of training. It's unconventional, and it would be off-brand for me to go on with this segment without having a little bit more fun. So I'd really like you to get involved. So let's get straight into it. What is sexual harassment? You don't have to answer this just yet. I want you to think about what it is and what's the first thought that comes into your mind when I say this. It's possible that you know legislation and that you're able to quote it, but what does that mean to you? Perhaps you'd be unafraid to admit that you're unsure of what sexual harassment is. I now open the floor for you to just throw your thoughts at me. What is sexual harassment, and what have you learned about it? I don't mind starting. Sexual harassment is unwanted conduct of a sexual nature. It is uncomfortable, yeah. It's unspoken of. The ambassador did say before that we don't. It's not usually, people don't bring it up because of the fear that they have in the workplace to do so. Yes.
It's quite disrespectful.
It's completely disrespectful. Yeah. Yes.
It makes you feel small.
It makes you feel small. Yeah. And yes, sir.
Inappropriate behavior.
Please.
Inappropriate behavior.
Inappropriate behavior, absolutely.
Forceful.
Forceful. Yeah. All of those statements are true. And when we speak about sexual harassment in the workplace, it's harassment that happens in the workplace of a sexual nature. It is unwanted and it's unwelcomed. And that's something that we need to, and something that I'll be repeating often. It's unwelcomed and unwanted. So the first things we think of are more obvious behaviors and the stories that we see in the press or stereotypes. But let me give you an example of these. For example, a 50-year-old senior partner at a firm who's notorious for getting 20-year-old interns to sleep with him. And a retiree who's often known for inviting young interns to Christmas functions and patting their knee under the table. Yep, holding a hug a little too long. So I want you to, I'm not sure, is the projector working? If that is, okay, not yet. A little bit later on, if we do have some time, I'll be showing you a skit on, and you'll have to try and figure out if this is sexual harassment or not. But moving on, I want to say that sexual harassment is not always direct and obvious. It's subtle. And it does not have to be perpetrated by a male to a woman who's the victim. It can be microaggressions that just chip away at your self-esteem. For example, for that, comments like, "Thanks, babe." You said earlier on, Mr. Ambassador, that these are innocent. They seem quite innocent. Commenting on someone's attire, like, "That dress looks so good on you." Worse, saying that dress looks so good on you, I bet that your boyfriend can't keep his hands off you when you're wearing that. Like you said earlier, it makes you feel uncomfortable. So it can be embedded in the culture of an organization, but it also could be a result of old power structures or gender imbalance or systematic misogyny and toxic masculinity. The harassment can come from people who identify as the same gender as you or people who don't. Sexual harassment can happen to anyone. It doesn't depend on age, race, gender, sexuality, marital status. I could go on. It does not have to come from someone who's more senior than you. The important thing to realize here is that it's anything of a sexual nature that makes someone feel uncomfortable, humiliated, intimidated, or threatened. And we move back to this point again. So this is one of the most fundamental points. It's how it makes the recipient feel. And it could be argued that what makes sexual harassment such a tricky topic, as you don't always know what someone's feeling. Also, who is the recipient? When it comes to sexual harassment, the recipient could equally be an observer of an event, someone whom the exchange or action wasn't directed at, a witness. And that person, too, can be made to feel uncomfortable. Sexual harassment can be physical, like touching, grabbing, equally sharing an indecent image on WhatsApp or email. It's often a pervasive behavior, and it equally could be a single event. So here we move on to the interactive part of this event, and I'm going to ask you a few questions on sexual harassment. From here, I just want you to give me a show of hands. Is it sexual harassment to ask a colleague out for a drink? Who says yes? Who says no? Just a show of hands. All right. Is it sexual harassment if the person who's asked says no? Show of hands for yes. Okay. And show of hands for no. Okay.
So far, so good.
Is it sexual harassment if the person who's being asked out for the drink is utterly offended that they've been asked and now feels uncomfortable working with the person who asked them? Show of hands for yes. And show of hands for no. It is quite tricky. What about if the colleague who was asked says yes? Is it sexual harassment then? Show of hands for yes. Okay, show of hands for no. Yeah. Okay, and then the last one would be, what if the colleague who asked said yes, And then they started flirting and touching each other in front of another colleague. And this colleague then found this display offensive. Shall I repeat that? Okay, so what if the colleague who was asked said yes, and then they start flirting and touching each other in front of another colleague who found this offensive? Is it then sexual harassment? Show of hands for yes. And show of hands for no. All right. One of the ambassadors were like, so far so good. Okay. You see, it's not completely obvious, and of course, there's so many more things to take into account. I said that one colleague asked another for a drink. I didn't describe the language used or the location of the conversation in theory, but even asking someone for a drink, that wouldn't be sexual harassment unless the person kept pushing and pushing after you've said no. Then it's sexual harassment. But if one had cornered the other while this question was being asked, had used a tone that implied threat or order, had a history of asking out every new person that comes into the company, and was making whoever feel uncomfortable, then that's sexual harassment. Like you said, sir, it's forceful. So some people don't think they're sexually harassing other people. Instead, they think that their behavior is acceptable, it's normal, or it's a joke. And in other environments, such as bars or clubs, you would think that it would be acceptable. But even then, there are boundaries. On the flip side, some people don't know or are equally unsure if they are being sexually harassed. And they often question themselves or blame themselves or think that they were being overly sensitive or think that they may have been leading this colleague on in some way. They're not sure if the harasser's behavior to other people would be acceptable or normal. But I bring you back to the original statement. It's how it makes the recipient feel. If it makes them feel uncomfortable, if it feels wrong to them, and the reason is because of their gender, their sexual orientation, or in some way it is related to sex, then it is sexual harassment. So how can we learn to recognize it? In work, as in life, we need to read the signals. There are some things to take notice of. For example, if someone suddenly tensed up, or they left the room, or turned their back on someone else, or was clearly trying to avoid them. Think about if you've seen this behavior. You don't have to answer, just think about the next things I'm about to say. Has someone's productivity suddenly changed? Are they coming to work less? Perhaps they've started lashing out or at their colleagues, or their behavior's changed. Of course, we won't always know what's going on in someone's life, and it could be something that's happening at home or an illness. But these are behaviors that are most common with people who are being harassed. And perhaps you haven't seen this type of behavior. Perhaps you've seen someone cornering someone else, or touching them, or getting into their space. Maybe commenting on someone's appearance. Are you aware of a colleague who's coercing or pressuring other members of the workforce to sleep with them in exchange for favors? Is someone bragging about this type of behavior? I would like you to take a moment to reflect on this. And do you think that you may have witnessed sexual harassment? Did you do anything to intervene when it happened? Did you call it out? And if you didn't, why not? I'm not trying to accuse anyone of anything. I do want you to think about this, though. I mean, what stopped you from intervening? Sexual harassment often is linked to a power imbalance. The workplace definition has hierarchical structures, and not only are those hierarchical, they're often patriarchal and heteronormative. They can favor the perpetrators. I'm not saying that only straight men who are at the top of the company are the ones who are carrying out this harassing, but I might argue that this demographic is more likely to be the victim. You can You can only change one factor, however, to get a sense of how this works. So, for example, I'll take a straight man who's a boss, change the boss to a woman, change the straight man from a boss to an intern. And all of a sudden, you start to see the vulnerabilities increase. So then, on top of that, I'll throw in homosexuality or gender nonconformity, and then mix it up with some race and socio-economic status, and those vulnerabilities rise all the way up. One thing we have to understand is sexual harassment might be linked to sexual desire, but it is often linked to power. Therefore, the difficult thing is knowing what to do about it, whether you're a victim or a witness. As the lawyer will outline, there is legal requirement to have a sexual harassment policy in place, and most companies do. However, there's still a culture of fear, as you mentioned earlier on, when it comes to reporting sexual harassment. People fear that they'll be victimized or retaliated against, or that they'll be seen as troublemakers. Men in the workplace are even less likely to report incidents. They feel shame or embarrassment. Often the perpetrators of harassment have the ability to hire or fire. So knowing who to trust can be also quite tricky. Institutions that have been around for long periods of time may have a history of enabling this type of behavior in the workplace. I'm aware that, in the entertainment industry, turning a blind eye has been one of the biggest factors to allowing systematic sexual harassment to be the commonplace for decades, until people started collectively speaking out, such as the Me Too movement. We interviewed one survivor recently, and her HR department asked her to keep her complaint quiet while they handled it. The perpetrator was a very senior member of the organization, and they'd previously stated that they were above protocol and defended their actions by saying that, the harassment that they perpetrated had been a misunderstanding between them and the victim, and nothing was done about it. Sexual harassment, like sexual assault and many forms of sexual violence, is often a case of one person's word against another. The British actress Michaela Cole, she created I May Destroy You, if anyone's seen that. So she says that, speaking out about these incidents takes a lot of strength, because some of them call it a gray area. Yet it's far from being gray. It's not a gray area. These behaviors are unprofessional, violent, and can destroy a person's perception of themselves and their place in the world and their career irreparably. Sexual harassment can force people out of their workforce place, and they'd rather resign and walk away than to, battle a system that's working against them. So, what do we do? Do we just accept this as the status quo? Or do we move on and we take proactive steps to address the issues? So this event shows the commitment of taking our proactive steps to eradicate this. And again, I want to thank everyone for coming and for your time, and for Mazars again for hosting this event. Training is key. We need to train people to understand what harassment is and how we can make sure that, we don't become perpetrators of it. We'll be talking a bit later on about the outline of the EASY training program. But as a takeaway for this evening, some things to bear in mind. We all need to understand boundaries, consent, and respect. We need to learn how to communicate professionally. We need to be advocates for those who cannot speak for themselves. Work should never be a place where someone feels fearful. So we need to stamp out not only sexual harassment, but bullying and harassment of all forms. And we need to just look out for each other, honestly. So to end this off, I just want to introduce you to one last segment, which is called, and it's actually really important, it's the concept of bystander intervention. Bystander intervention is one key of tackling sexual harassment, And we have a section in the training which I'm going to share some concepts with you now. So if you witness sexual harassment or any kind of harassing or bullying behavior, it's difficult to know what to do. Sometimes your mind slows down and sometimes the moment's already passed and you can't do anything about it, or you think you can't. Maybe the person who's harassing you is your boss and you fear loss of employment, or your friend and you think that, maybe someone else should handle this instead of you. By learning some bystander intervention techniques, you can learn to make safe and positive ways to act or intervene when something like this is taking place. Bystanders can be male or female, gender non-conforming, but never underestimate the power of a male ally. It appears it is easier for men to call out other men's behavior, and in the same breath, for women to call out other women's behavior. So do take this into account when you are deciding to help someone. Again, you don't have to shame the person publicly to make your point. You can just as easily take them aside and let them know that their behavior is not okay. Bystanders can be anyone, from interns to senior execs. Although if a bystander is a manager or a supervisor, they have the duty to also report the incidents. As a bystander, what you can do, you don't have to make a big scene. You can divert or distract. You might cut in, ask the victim if they need help with something in a different location. You can put your body between the two people, perhaps reaching out for something. You can check in with the person you suspect that is being harassed and ask them if they're okay, if there's anything that you can do to help. Remember, whatever you do, if you make a decision to do something, you're letting the victim know that they're not alone and that you've witnessed this happening, which is important. So to sum it up, before we move on to the legal section, and to introduce you to our training program, sexual harassment is sexual harassment if it feels like it is to the person who's received it. Yeah. The comment, the touch, the look, the proposition, the whistle, the picture, the email, text, the suggestion, the joke. If any of these are related to sex, sexual identity, gender, or sexual orientation, then it is sexual harassment. The fact that we're all here together in this room today shows that we are committed to changing the status quo. And again, I say thank you for hosting and thank you for coming. So let's all take initiative this evening to make the places we work safer, more respectable, and more productive for everyone. A break? Okay. Thank you, Joe. You said 1 minute break. Okay. All right. That was a lot of information to take in. We will be taking a 1 minute break before we continue, and I'll be back here to introduce our next segment. All right. Looking at what we've discussed so far, I would like to put on a skit and let's see if you can identify what sexual harassment is. I could identify a number of things wrong in that script. In that skit. I mean, from it looks like catcalling, touching people without permission, taking pictures of someone without their permission. We can go on the whole night. For this next segment of the program, we'll focus on the illegal obligations and responsibilities to prevent and deal with sexual harassment in the workplace. For this, I'm pleased to welcome a team of legal employment lawyers from Fasken, Vinolan Naidu, Tshepiso Rasetlola, and Andy Michaelo. Fasken is a full-service law firm with offices in South Africa, Canada, UK, and China, and they've been operating for 130 years. In this session, Vinolan, Tshepiso, and Andy will help us unpack what South African law and jurisprudence says about sexual harassment, the steps employers must take to address it, and the legalities, and their liability. Please come onto stage. Thank you.
Good evening, ladies and gentlemen. Am I audible enough for the room? Thank you very much, Tina. Your presentation was very thought-provoking. It unpacked a lot of things that I also mentioned left unsaid, unspoken of. It's like a taboo for you to speak out against sexual harassment. I think it's worth noting that this event or this discussion comes at a time where we have seen our judiciary being very heavy-handed on perpetrators of sexual harassment in the workplace. The High Court has recently awarded an employee approximately 4 million rands in damages after being sexually assaulted by a supervisor in the workplace, which is to be paid by the perpetrator and the employer. So it's becoming quite expensive for the employer to look away at sexual harassment in the workplace. Most often than not, a harasser is not an unfamiliar person to his or her victim. It can therefore be argued that the challenge of accomplishing gender equality is that people's attributes, perceptions, and behaviors have to be re-socialized to inculcate principles of respect and human dignity. The ultimate solution for achieving a harassment-free workplace lies predominantly in the predominance of education in transforming people's attitudes and enhancing respect for other employees' human dignity. Because like most of you have mentioned during Tina's presentation, is that it impairs how you view yourself. It diminishes how you value yourself solely because of how someone else treats or does not respect your privacy, your bodily integrity, and your human dignity. Cases such as the recent High Court case serve as a wake-up call to all employers to endeavor to take reasonable steps at all times to eradicate sexual harassment in the workplace. Our presentation will deal with the law governing the handling of sexual harassment grievances in the workplace, the different forms of sexual harassment, the tests for sexual harassment, and the consequences of an employer failing to take reasonable steps in addressing this subject matter. What is sexual harassment? Adding on to what Tina has already outlined. Sexual harassment is prohibited by several legislative provisions, not only in South Africa, but at the world at large, and is acknowledged as a form of unfair discrimination. In certain instances, an employer may be held vicariously liable for acts of sexual harassment perpetrated by their employers, or even for sexual harassment perpetrated against their employers by third parties, and where an employer fails to intervene. I have already highlighted that there have been instances where employers have been victims of sexual harassment and have successfully claimed compensation against their employers on the basis of constructive dismissal, unfair discrimination, and a failure by the employer to provide a safe working environment for their employees. Now, in South Africa, where do we find the governing and guiding principles of dealing with sexual harassment in the workplace? The answer is the Employment Equity Act. The Employment Equity Act is the primary legislation which provides for protective mechanisms for employees against sexual harassment in the workplace. Now, in terms of Section 6 of the Employment Equity Act, harassment of an employee is a form of unfair discrimination, and it is prohibited on any or one of the combination of the grounds of unfair discrimination as listed in the Act, and which will be dealt with in detail by my colleague, Andy Michaelo. In terms of Section 23 of the Labor Relations Act, any person interpreting or applying the Employment Equity Act or any other act must take into account any relevant code of good practice. Now, what the legislation did is that after enacting the Employment Equity Act, they put in a simpler way that an employer can be able to interpret the Employment Equity Act, and steps and guidance as to what do they need to do or what they're expected to do in dealing with sexual harassment in the workplace. Now, the code provides guidelines on what constitutes sexual harassment, the guidelines on measures employers should put in place in addressing sexual harassment in the workplace. I will now hand over to my colleague, Andy Michaelo, who will now deal with the definition as per the Act, the different forms of sexual harassment as outlined in the Act, and the test to be applied when the court interprets sexual harassment as perpetrated in the workplace. Over to you, Andy.
Quite short. I thought this would be a bit lower, so I'll try my best. Just going to take this off. So as Sipiso has mentioned, good evening everyone, by the way. Sorry about that. As Sipiso has mentioned, we have two codes of good practice that have been issued to deal with sexual harassment in the workplace. There's a 1998 code and a 2005 code. Interestingly, the 2005 code doesn't replace the 1998 code. So when assessing sexual harassment, employers should have cognizance to both codes of good practice. So if we look at the code of good practice, how do they define sexual harassment? Sexual harassment is defined in the code to be unwelcome conduct of a sexual nature that violates the rights of an employee and constitutes a barrier to equity in the workplace. So out of that, we extract three key provisions, which is it must be unwelcome, must be of a sexual nature, and it must have the ability to impair a person's dignity. Those are the main principles that we can extract from. That. Now, the 2005 code, it sets out specific factors that employers are supposed to take into account when assessing whether, or the courts, sorry, employers or the courts, as to whether or not something would constitute sexual harassment. And these include whether the harassment is on the prohibited grounds of sex and or gender or sexual orientation, because if it's not, it could relate to harassment, but it just won't be sexual harassment. It would be another form of harassment. Whether the sexual conduct was unwelcome, the nature and the extent of the sexual conduct, and the impact of the sexual conduct on the employee. So those are factors that the code sets out to try and enable employers and courts to assess whether there'd be an instance of sexual harassment. In terms of forms of sexual harassment, as already has been stated, it's obviously not just physical. It can also be verbal as well as non-verbal. So non-verbal gestures, body language, pictures, that would all constitute non-verbal. And then obviously verbal would be your comments, remarks, etc. And then physical would obviously be physical acts of sexual harassment. And all three are recognized. It doesn't just have to be physical or verbal for it to constitute sexual harassment. Keep on doing this, sorry. So now if we look at what the courts have said. So it's correct, South Africa has a zero tolerance for sexual harassment. And what we'll see through these cases specifically is how the courts have tried to tackle sexual harassment. And you'll see in some instances the lower courts sometimes have got it wrong. And when it's challenged and taken higher to the higher courts, we have clearer authority as to where we stand. And spoiler alert, most of the cases obviously confirm that there is a zero tolerance to sexual harassment in the workplace. And yeah, I'll just touch on some of the interesting cases. And I'm just going to read some of the facts of the case studies, just so that we can see how the courts have dealt with. Because in this case, the Campbell Scientific Africa case, it was regarded by two courts as this was a once-off. One comment was left at that, was just trying his luck. When there was no reciprocal, indication, he left it at that. And shouldn't that not be sexual harassment? So quickly just briefly state the facts. So Mr. Simmers was a senior employee of Campbell Scientific Africa, just referred to it as CSA. And basically he was called to attend a disciplinary hearing on allegations of sexual harassment, unprofessional conduct, and bringing the company into disrepute. What had happened is that Simmers accompanied another contractor, Mr. LaRue, and a CSA consultant to Botswana for a site visit, where they were going to install some electrical equipment at a Botswana power station. And basically they stayed the night there, and the three of them had supper together. And at some point after the supper, when they were in the parking lot, getting in the car to go back to their respective rooms, Mr. Simmers said to Ms. Marquise, who was the consultant, "Do you need a lover tonight?" So Marquise was a bit, shocked. But she made it clear to Mr. Simmers that she did not, and that she had a boyfriend. And Mr. Simmers responded, "If you change your mind during the night, come to my room." Marquise did not change her mind, but Mr. Simmers did not pursue the matter further. So he left it at that. She didn't come, and he didn't, phone her where he left it at that. The next day, Marquides, who was the complainant, mentioned the incident to Mr. LaRue before leaving to Australia. She wasn't employed by CBA. She was a consultant that was accompanying them. And basically, Mr. LaRue then mentioned the incident to CBA's managing director, who then asked Marquides, the complainant, to provide an email, just an email of what actually happened and what took place. And long story short, Mr. Simmers was called to a disciplinary inquiry to answer to allegations of sexual harassment, and he was found guilty and he was dismissed. He then went to the Commission for Conciliation, Mediation and Arbitration, the CCMA, to challenge his dismissal on the basis that it wasn't fair. In the arbitration proceedings, the arbitrator concluded that the sexual harassment complained of was relevant to the workplace, and although Marquides was not an employee of CSA, the incident occurred outside of working hours. He did find, however, that the proposal to Marquides was sexual harassment in the form of unwanted sexual advances, and he ruled that this was fair. Being aggrieved with that outcome, Mr. Simmers took it to the Labour Court for review, and the Labour Court held a different view to the Commissioner. And the Labour Court held that it was a single incident of sexual harassment and it wasn't serious. And in order for it to be sexual harassment, it must impair the complainant's dignity. And because Mr. Simmers did not persist in his gestures, it was, a once-off incident, it wouldn't constitute sexual harassment, and therefore reversed the CCMA finding and felt that his dismissal was unfair. Then aggrieved with that, Campbell Scientific Africa then took it to the Labour Appeal Court on appeal. And that's where the latest decision was. And the Labour Appeal Court, I just want to read you exactly what they found. They found that, so one of the arguments was that the employee, Mr. Simmers, wasn't able to be disciplined because it wasn't an employee of the workplace. The Labour Appeal Court found that CSA was entitled to discipline Simmers for his misconduct, and the Labour Appeal Court held that the Labour Court had erred in finding that the advances were not harassment, and that it was not serious, etc. And the Labour Appeal Court held essentially the following, that in treating the conduct as sexual harassment, the complainant and other women such as her are ensured of their entitlement to engage constructively and on an equal basis in the workplace without unwarranted interference upon their dignity and integrity. And this is what the Constitution ultimately affords. And it held that it was sexual harassment, even though it was, whether it was trying his luck, and therefore found that the original dismissal was substantively and procedurally fair. So that is an instance of the court saying, no, one instance, it doesn't have to be persistent for it to be sexual harassment. Depending on the facts and circumstances of the case, one single incident can qualify as sexual harassment. The last case I'll just quickly touch on before I move on, before I hand over to my colleague, is the Rustenburg-Platz case. And that's a very interesting case. So basically in that case, Rustenburg had employed an employee, we'll just refer to her as Jane for now, and she was a boilermaker. And during the course of 2017, Stephen Peterson, the accused, alleged that Jane had committed misconduct and called her to a disciplinary hearing. And despite him wanting her to be dismissed, she was given a final written warning. Thereafter, Peterson's first instance of sexual harassment against Jane occurred at a workplace function, which was hosted by the applicant, which is Rustenburg. At this function, Peterson approached Jane and asked her how she was capable of surviving on her salary, because it was such a low salary. And he suggested that in return for her sleeping with him, they would be able to share the costs of any accommodation, and that she would be in a better financial situation if she was to sleep with him. So Jane rejected Peterson's offer, and similar conduct, including suggestions that she should sleep with him, consisted over, carried on over 7 years. Despite this, the complainant never came forward and never raised, these concerns. And the reason why is she said that because she had previously been called to disciplinary inquiry in relation to unrelated matters, it looked like she was just sour with the supervisor because he had instituted it, and that in retaliation she had raised this. So she kept quiet for 7 years. She just let this continue and continue. And basically in 2014, Peterson requested the complainant perform a task that was totally unrelated to what her duties were. And this request, combined with the continued sexual harassment over the years, was her breaking point. And she refused to do the additional tasks. And she also went forward and leveled charges of sexual harassment against Peterson. Basically, Peterson was then called to a disciplinary hearing where he was found guilty of sexual harassment and he was dismissed. He then referred an unfair dismissal dispute to the CCMA. And basically, the CCMA found that his conduct could not have been regarded as sexual harassment because he didn't know that the victim had taken offense to it. She didn't say no, or she didn't report it. So her silence kind of was consent for the sexual harassment. And basically, the CCMA found that it wasn't sexual harassment, and that because the complainant had taken so long to come forward, it doubted the credibility of the complainant. On review to the Labour Appeal Court, the Labour Court reversed that decision and found that it did definitely constitute sexual harassment and that his dismissal was fair. And in this line of reasoning, the Labour Court highlighted the patriarchal undertones in requiring a victim of sexual harassment to inform the assailant that their conduct was both unwanted and offensive, and that no such requirement is necessary to prove sexual harassment. So just because she didn't repeatedly say no, 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 and that it persisted over all these years, that doesn't mean that it didn't constitute sexual harassment. So essentially what I think these two cases specifically illustrate is that our courts are, have taken the stance that they are aligning to a zero tolerance of sexual harassment, and that's a good position to be in. So yeah, I'm going to hand over now to my colleague Vanolan, who will deal with an employer's liability and other aspects.
Hi, good evening, everyone. Just getting our computer. Okay, so I'm going to continue with some case law discussion, because we just love, as lawyers, to discuss cases. So this is the last case. So it's Liberty Group versus MM. This was an appeal by the employer to the Labour Appeal Court after the Labour Court found it should be liable to compensate the employee for 250,000 Rand damages, which I thought was quite a conservative figure. And this was due to the employer failing to take reasonable steps to address the sexual harassment incident at its workplace. So in this case, the employee, Ms. MM, resigned given her indication that the working environment became intolerable due to the ongoing or continued sexual harassment by her manager. And so she resigned, and she stated as follows: I reported the harassment to management, and Liberty Life failed to react. However, I later discovered that Andrew Mosesi, the manager in question, was contacted and informed of the matter in my absence, but nobody came back to me to help me to deal with the situation or to resolve this issue. In this matter, the employee was sexually harassed on 4 occasions. She did not raise the matter as she feared her insecurity for her job. The employee then set up a call with her official from HR, a Mr. Haynes from the employer's HR department, as indicated, and she raised the issues of sexual harassment. After the call, her manager, Mr. Mosesi, contacted her and said that he was aware of the call to HR. As a result, the employee resigned from her employment with her employer, claiming intolerable working environment. In response, her team leader, Ms. Inyati, contacted Ms. MM. The employee told her team leader about the sexual harassment, and Ms. Inyati was sympathetic and asked her not to resign so that the employer could deal with the matter. In evidence, it was held that the employee tore up the resignation letter, given Ms. Inyati's indication that the issue would be addressed by Liberty. Following a 2-week period from her withdrawal of the resignation, The employee took no steps to investigate the sexual harassment complaint. The employee, as a consequence, resigned for the second time. A week later, she referred a dispute to the CCMA. During this period, the employer investigated the complaint. The employee failed to cooperate. The employee failed to cooperate with the employer, and in her own words said the employer had not cooperated with her, was doing too little, too late, and that she did not trust the employer any longer. So the Labour Appeal Court had to decide whether it should grant the employer's appeal because it believed that it took steps, and had this to say. It says that the Employment Equity Act requires every employer to promote equal opportunity in the workplace and ensure that no person unfairly discriminates directly or indirectly against an employee in any employment policy or practice on one or more grounds, which includes harassment. Although Ms. MM's reporting of the incident was not done immediately, as envisaged by the Employment Equity Act, the Labour Appeal Court was satisfied in its interpretation of the relevant provisions of the Act and indicated it was dealt with within a sufficient time. The Labour Court, it held, correctly found that having brought the conduct to the attention of the appellant, the steps required by Section 60, which I'll deal with next, one must consult with the relevant parties and take necessary steps to eliminate the alleged conduct and comply with the provisions of the Act. The effect of the employer's HR informing Mr. Mosesi, the manager in question of this communication, was that the employer failed to take the positive steps to protect the employee in the manner contemplated by both its own policy and the Employment Equity Act. The absence of any investigation into the issue until after the respondent had resigned for the second time was glaring. No investigation into the sexual harassment complaint ensued until the second resignation. The employer failed to have regard to its the employer failed to have regard to its failure to adhere to its own policy as indicated. And the employer not only failed to regard the purpose and objects of the Employment Equity Act, it also failed to recognize the seriousness of the conduct, lack of interest in resolving the issue, and the failure to consult and take the necessary steps. The appeal by the employer not to be held liable failed, and it was ordered to pay the employee the compensation as indicated of 250,000 Rand. So this is a good case in point where the employer fails to take any steps. It sits and at the last minute when the damage is already done, then attempts to do damage control. And this is against what the Employment Equity Act, what it stipulates. So the next part of my segment is the prohibition of harassment under the EEA. And as you can see on the screen, that it's under Section 6 of the Employment Equity Act, which defines harassment as one of the grounds of unfair discrimination. As we can see, it can be both a single ground and it can be a combination of other grounds. So this is defined under the Employment Equity Act amongst other grounds such as race, age, gender, and so forth. And of course, if one is unfairly discriminated, then the employer is at risk for an unfair discrimination claim should steps not be taken to eliminate this form of conduct. If we move on to the next slide. We'll just wait. Under Section 60, now this is a very important provision under the Employment Equity Act. As we've seen in the Liberty Group case, the Employment Equity Act creates a form of vicarious liability on the employer. And so this is the definition under these 4 blocks. So if an employer fails to meet this threshold or comply with these requirements, it would be liable under the section. So it becomes the perpetrator, for lack of a better word, and is liable. And the Act goes to this extent because it really has this zero tolerance as indicated by Piso and Andy. So from a practical sense, I mean, what steps can an employer do to prevent itself from becoming liable, to promote a culture of intolerability of sexual harassment? Well, It depends on every case. I mean, of course, you need to consult with the complainant or victim employee. You need to consult with all other parties. One needs to identify the nature and the extent of the sexual harassment. Indeed, one needs to immediately investigate the matter, provide counseling and support to the victim employee, give the matter the sensitivity and confidentiality that it deserves, obtaining feedback from the employee, the victim, as to what relief they would seek to address the incident. And based on the outcome of an investigation, consult with the employee and other relevant parties, and then taking immediate disciplinary action against the perpetrating employee and any other recourse as may be necessary. And of course, ensuring that such conduct does not repeat. From a mitigatory or avoidance perspective, and in view of the spirit and purport of the Employment Equity Act, what steps can an employer take? Well, creating a working environment that is harmonious, safe, promotes equity in the workplace, values the respect and dignity of all employees. Importantly, having policies in place, procedures, systems that give effect to this and has adequate mechanisms to address complaints of this nature, and where it requires strict adherence by all impacted by policy. So, under law, employers are not required to have a policy. I mean, the Code of Good Practice, as mentioned by Andy and Sapiso, would suffice. But if you have in a larger organization with as many employees, this is recommended. Another factor from a mitigatory or avoidance perspective is creating platforms that brings awareness to this type of conduct. For example, we heard today having this discussion on sexual harassment. This is a form of awareness and gaining knowledge and attempts to instill a culture that does not tolerate or nor condone any form of this conduct. And of course, training employees or bringing about, training them and to inform them of the various types. Many employees don't know this, and sometimes one can avoid this conduct from happening. Importantly, making it easier and accessible for an employee to bring this to the attention of an employer, as opposed to perceived barriers in the workplace. So many times, as indicated earlier on, that a victim is not going to be very willingly going to inform or report the incident. It's sometimes seen as tabooed. They fear their job, as indicated in the MM case when Ms. MM didn't want to. She felt there was a job insecurity to have reported it immediately. So having a policy or making known that it is something that is open door to a manager, and of course having a climate in which victims will not feel that their grievances are ignored or trivialized, and that it will be dealt with in a confidential manner. I think that's important. So that brings me to the end of our presentation. I just want to say we thank you for giving us the privilege to speak on this auspicious event. Of course, for those attending, the dignitaries, officials, and those streaming through. And I want to add that this impacts not only on the workplace, but our society at large. It's a much bigger picture. And we look forward to taking your questions. Thank you.
No worries. Thank you so much to Vinolin, Tsepiso, and Andy, just for taking us through the legalities and practical steps on what employers can do to deal with sexual harassment in the workplace. And I think it's also very useful to better understand what the liability is for an employer when a situation like this arises. I think we've had a lot of information thrown at us up until this point, and I think this is a good time for us to just take a break and maybe answer a few questions to the online viewers as well. We will be taking one or two of your questions as well. So this is our Q&A section. There will be a mic going around, so do please just lift up your hand and we'll take it from there. Okay. Well, if you lift up your hand, then I'll bring through the mic. I'll check for online questions as well. Oh, we do have a question at the back.
Good evening. Thank you for that information. I think that was quite useful. I'm Thokozile from Absa Bank, and I work in a team that tackles, as part of employee work, we work on gender-based violence and programs. My question is, if an employee is taking the company now to court and is doing the whole process that you just talked about there, are they using their personal funds to do that? If they need a lawyer, and if they do that, I understand that some people might be challenged financially when it comes to getting funds to tackle corporate and the company that you work for. So that's my first question. Are they using personal funds? And if they are there NGOs or organizations that help employees who need to take their own company to court, because companies do have an endless budget when it comes to these things?
I'm not sure if everyone heard that, but I will be repeating this question. So can employees, when employees do take companies to court, are they using their own personal funds? Or are there NGOs, organizations that can assist with this?
Thanks for your question. So the first answer to your question is, unfortunately, the employee would need to incur the legal expenses. So if you're going to go to the CCMA or Labour Court, the employee will need to fund that litigation. And then to answer your second question, if I understood it correctly, there are organizations such as the South African Society for Labour Law that provides pro bono services. There's the Legal Resource Center, there's the Legal Aid Clinic. I know the Legal Resource Center does more public interest. There's quite a few organizations that can assist employee parties who are victims of sexual harassment. So yes, I hope that answered your question.
Are there any other questions? We have someone in the middle.
Thank you. My question is, if someone in a company is found guilty of misconduct in the company for different reasons, say financial mismanagement, from what I understand, there's not necessarily an obligation on the company to tell the employees why they were dismissed. Am I right in saying that? Is it different if it is sexual assault or sexual harassment and they could pose a threat, like maybe at their future employer? So is there an obligation on an employer to inform employees why someone was dismissed when it is of a sexual nature?
Did you get this question? Okay.
I would say I would say the short answer is no. That the reasons for dismissal must be kept confidential by the employer, and this would extend to instances of sexual harassment. Because that would relate to personal information, etc. So I would say that it wouldn't be different in the case of sexual harassment. The perpetrator or the alleged, he still has rights, in terms of confidentiality, etc. So I would say he wouldn't be allowed to, go and publish that and publish the reasons for why he was dismissed, as would be required by REDS or another institution or another legislative framework.
We have another question. Thank you, Andy.
I just want to check on that point, because what I've noticed is that perpetrators often reinvent themselves and they go into other spaces and they do the exact same thing, and they perpetuate their behavior. So how do we work against that?
If it is unknown to the public that that's what they were dismissed for.
I think Nolan would be best. Not to throw him.
Yeah. So it depends. So if somebody is dismissed, I may want to add perhaps to Andy's answer. If somebody's dismissed in a disciplinary inquiry for sexual harassment, it's open that the person did the deed. The employer has an obligation, I would think, to inform possible employers who are looking for a reference, for example, to inform of what has happened. It's a different story if there's a settlement agreement, which normally is confidential, but ordinarily if that person is dismissed, the employer can disclose the fact that he or she was dismissed for the harassment. So I think that should hopefully assist to some extent. Sometimes there are agreements with these types of cases. It's a hush-hush type of affair where the employee who's alleged to have committed the act, tries to settle. A lot of times where they have no case, they would say that. From a legal perspective, yeah, it is a very difficult position from an employer because you want to make it known to future employees that this conduct does not repeat itself. But yeah, I hope I've tried to answer your question.
Thank you, Vanola. Are you happy with this answer?
I'm not happy with it, but
I mean, it is what it is. No, I was just wondering if you had a follow-up, perhaps. Yes, please.
Oh, okay. So just a follow-up on that. What about the sexual offenders register? Does, if you have been found guilty of sexual harassment, isn't there an obligation? Or does it, I don't know, I thought I heard that there's a sexual offenders register that exists, right? So is there no responsibility on the employer to report such a person to be added to such a register?
Does South Africa have one?
yes, yes.
Okay, so yeah, I think that would be a way to prevent this from happening. One can report it. The employer would then be duty bound to report it. The question is an employer duty bound? Under present legislation, there isn't, and I think it is something for debate. Perhaps want to amend the code of practice for the employer to, they must report it to a sexual offenders register. Another way to try and answer your question is if there's sexual harassment, it's also a crime under the criminal offense. I mean, there's common law and there's obviously the legislation on sexual assault. And in that instance, the employer has an obligation to report it to the South African Police Service or the authorities. And if it's obviously investigated and the perpetrator in question is convicted, that becomes a public record. He has a criminal conviction, he or she has a criminal conviction, and that to me is a way to have a scar on that person's name. So I think employees should be doing that if it was clear that there was sexual assault. So I hope that should assist as well in trying to answer.
So is it a legal requirement for the employer to report?
Yeah. So unfortunately, there's no peremptory legal obligations on the employer to report. So it'll be the complainant who would then report it to the. Yes, correct. So insofar as labor legislation is concerned, there's no obligatory or positive duty for the employer to report. On the sexual register, however, perhaps the employer may do so voluntarily. I see no prohibition there, but I think there's no legal requirement, unfortunately. Perhaps there should be amendments with laws.
All right, I do have one online as well. So just two more questions from our audience.
Hi, I just want to pick up on Linda's point, and I can understand clearly why she's not happy with the answer. I work in a sector, in the public interest law sector, by the way, and social justice movement, and it's one of the sectors that's actually rife with sexual harassment. And so it's been going on for decades and decades and decades. About 2.5 years ago, I took over the leadership of an organization where perpetrators were abusing candidate attorneys for over a 15-year period. And women in the organization, leadership, Women in leadership turned a blind eye to it, swept it under the carpet, and nobody understands why. And yet, they project themselves as feminists out there on the streets and on and on and on. So I can't take all the credit, but it's more of an input. What we did is that Linda's point is people that perpetrate this reinvent themselves as consultants. So they don't appear as employees anywhere on anybody's books, okay? So they work in the sector, they get paid as a consultant, nobody knows. And we found out about this, the guy that was doing it in the organization where I worked. And about 20 public interest law organizations and social justice organizations came together. And we said, okay, we will create our own register, because the guy cannot get away with this for all these decades, and that's how we work with it. So it's not a question, it's more of an input of how the sector works. And I think it's something to be shared. We've designed sexual harassment policies, we've shared it within the sector, because we don't want to reinvent the wheel. The law is the law, it's very, very clear. We've got sexual harassment champions in all of our offices, someone that's trusted, but also at the same time, you can't have a policy as a tick-off list. It's an ongoing awareness that you have to raise all the time. Thank you very much.
Thank you. I do have one online question. It seems a bit of a statement, and I'm not. They say, do settlement agreements not perpetrate the unsavory practice?
Yeah, that's a very good statement, and I indicated before. I think it does. I think what happens is the employer, you have a disciplinary inquiry. This happens in various types of misconduct. And then the perpetrator would say, look, I'm prepared to settle. And what they normally do is they want their name because they're able to gain future employment. And the employer, doesn't want to incur the legal expenses as one of the factors. They're obviously getting the employee to leave their employment, so this elimination and their possible liability under Section 60 is gone. But they signed this agreement, which is ordinarily is confidential, and you absolutely right. The person that's given that statement is indeed right. It does perpetuate. So you have this person then goes back to society and carries on with the conduct, because if they do it once, they can do it again. So I think it does, but the reality is settlements are, by their nature, confidential. So if that's not going to be the case, then the employee parties can say, well, you can just proceed with disciplining me and dismissing me. And in that instance, the employer can then mention that the nature of dismissal due to the sexual harassment. But that's correct.
Thank you. Can we take one more? And then we'll move on to the last segment.
Hi. I just wanted to know, is there some form of gauge when it comes to settlements? Because it seems like one case they settled with like less amount than the other case. Is there some form of gauge that is used compared to like what type of sexual offense it was and how long it was, or like what is the case with that?
There's no fixed gauge that we use. Usually we advise the client would look at how long it will take to fight it out in the CCMA or in the labor court, and how much the other party or the perpetrator is willing to take. So sometimes, as a perpetrator, you bring an offer to the table to say, I'm willing to settle for 6 months' salary, for example. Then the employer will then come and say, looking at how much we're looking at spending on litigation, we are willing to just offer you 3 months or 2 months. So it's all about negotiation, give or take. There's no fixed amount to say when it's sexual harassment that's of a physical nature, we're only willing to settle for 6 months or for 10 million rands. And if it's only non-verbal, it's only going to be 2,000 rands. No, it's about negotiation. There's a negotiation that goes on between the perpetrator and the employer or the company, and the settlement arrives as a consequence of us meeting each other, sometimes halfway, sometimes one party then ends up giving in and saying, no, it's fine, just to make the matter go away. Most often than not, it's a perpetrator, because they know that if we enter into a settlement, like Van Olen has said, your name will not be tarnished. When you go and look for employment, no one would know that you've been dismissed for sexual harassment and so forth. But I would like to add on to say, as an employer, you also have an obligation to be honest in your references. Don't say that, no, the contract just ended mutually, or it was a mutual separation, unless there's a settlement agreement that prohibits you from disclosing the reason why the employee was dismissed. But if it's normal dismissal, you also have an obligation, if you're called as a reference, to say, no, look, this is what we experienced with this employee. These are the risks that you're taking by employing this employee, given this information that we're giving you. And it's up to you whether you want to hire him based on this information. But unfortunately, where there's a settlement agreement, you can't say that. You just have to say the contract was terminated mutually between the parties, and that's that.
No, it does. If I may add on to Sapiso. So, I mean, let's look up ways we can work around this for employers who do want to try and prevent this. Maybe you can have a policy that says if somebody's charged or if we're in disciplinary inquiry for sexual harassment, it is their duty bound in terms of policy to consult with the victim and find out what possible relief that the victim would want. Because maybe the victim wouldn't want settlement. Maybe the victim wouldn't want confidentiality and that person to go scot-free, though they're leaving the employer. Maybe the victim wants the person to be dismissed and their name to have that. And a policy can have that. And then the company then is duty bound to comply with that policy. It cannot then settle because the policy says otherwise. Under law, there's a thing where parties are entitled, they have this, freedom of contracting. But if your policy says otherwise, the victim then can even pursue, let's just say hypothetically, the employer settles confidentially, but the policy says otherwise. The victim then will have a case against the employer for doing so. There's even common law damages. We refer to the cases under Section 60. There's case law, we don't want to go too much into detail with the presentation, where you can sue for common law damages, not beyond the Employment Equity Act. In that instance, the victim employee can then pursue recourse to say, well, the employer didn't comply with its policy, and his name is, being tarnished. They've been, dignity has been impaired, and so forth, and the employer disregarded it. That's one of the ways to work around it.
The settlement feels like putting some form of work on the person's dignity when you can't really put that work on. Like, you're not really worth 250,000 or $1 million. You can't really put a work on that dignity. So thank you for answering that question.
Thank you all for your questions, and thank you to our speakers for taking the time to answer them and giving us a better understanding on this issue. I would like to swiftly move along to our last segment. So this last segment will focus on solutions to help employers and HR professionals navigate and deal with sexual harassment in the workplace, particularly when it comes to their knowledge and the latest requirements and training their staff on this issue. For this, two members of the EZA team the EZ training team. It is a great movie. But for this part of the segment, two members of the EZ training team will give us an overview of the course that they've been working on with support from the French and Dutch embassies. I'd like to welcome onto stage Dr. Emil Harhoff and Stefan van der Walt.
Thank you very much, Tina. Good evening, guests. Good evening, honorable ambassadors. My name is Dr. Emil Harhoff. This is my colleague, Stefan van der Walt. We are expecting a quick power surge in the next few minutes, so if it goes dark for a second, we'll just reconvene after that.
Good evening, guests. We are here to present a brand new online training company called Easy Training. Oh, it feels quite surreal to stand here and say that. We've been working on this for quite a while, but we are dedicated to HR compliance specific to the South African work environment and to ensure safe, trusting, and efficient workspaces. Now, we've been here for quite a while and we've listened to incredible information. I don't know about you guys, but I'm feeling slightly overwhelmed with all the information, from the legalities to like trying to remember what was the actual definition of sexual harassment. It's getting a little bit lot, so why don't we just have a breather, take a moment, and want to show you a little skit on because I'm sure they're going to relate.
Hey.
Is this sexual harassment?
No, this isn't sexual harassment. This is just me being sweet.
You being sweet? I kept showing you that I wasn't interested and you kept pressurizing me.
No, that wasn't pressure. That was just me bringing in my A game.
Your A game. I said no again and again, and you kept pushing it. It made coming into work and being in the same space with you each day really awful for me.
Oh, okay. But in my defense, I don't think I actually ever heard you say no.
You didn't hear me say no. Hold on. Let's have a look at that skit again and let's see if we can actually spot the no's when we are looking for them. There's a verbal no. There's a non-verbal no. There I found an excuse not to